Welcome to the First District Court of Appeals. We have one case on the docket this morning, case number C-24-0505, State of Ohio versus Hydea Fields. I see counsel is present in the courtroom. Are you both ready to proceed?
Yes, Your Honor. David Hoffman, ready to proceed.
Yes, Your Honor. Dakota Parish of the City of Cincinnati, ready to proceed.
All right, Mr. Hoffman, if you would like to come forward. Would you like to reserve time for rebuttal?
5 minutes for rebuttal, please, Your Honor.
All right. You may start when you're ready.
May it please the Court, Mr. Parrish, I wanted to focus on the second assignment of error with regard to the exclusion of the victim's prior acts of violence. And I note that the Weatherall case indicated that that this type of evidence in a self-defense case should be admissible to prove the defendant's state of mind.
But only when the defendant knows of the information, right?
That's correct. And also, under 405, it looks like you're supposed to open up with reputation and opinion evidence, and then on cross-examination, maybe specific instances of conduct. But anyway, I think that from the transcripts, it appears that the defendant did know of these events, attempted to testify to them, but was not able to.
Was there a proffer of what the defendant would have testified to? Do we know what the information would have been?
There was no formal proffer.
And how does that affect the analysis of this assignment of error, if at all?
Well, I think that it doesn't necessarily shut it down. I think that defense counsel indicated the reason for the evidence being offered. The question posed to the witness indicated that the defense counsel intended to elicit specific acts of violence against in prior relationships by the victim.
And that's what I find interesting about this case, because I think that you would say that the record is clear as to what was the purpose of the testimony that was being elicited, and oftentimes we don't have that. You know?
It seems like it's always.
So this time, like we know why, that it wasn't intended to be prior bad acts. So, I guess if we were to find error, how would you address whether it's harmless?
Well, it would have to do with the comment. I think the comment is the big elephant in the room in this case. My client's comment. The trial court made a finding that before she sprayed the victim with the mace, she made a comment about the exchange, the email exchange, and it was based upon that the trial court felt that not only was she at fault, but she didn't have a reasonable fear. Now, that reasonable fear is what...
Because the trial court credited the victim's testimony where there was a difference between your client and the victim, right?
Credited victims.
In
that respect, yes.
Yeah.
In that respect, yes. The trial court did. Made a finding to that effect, and that's the finding. Now, I believe that having a reasonable, I might have even mentioned in this argument that it was a reasonable fear. It's not a reasonable fear. It's a reasonable belief that the defendant would be heading for physical harm. That's what has to be found in order for self-defense to be a viable claim. And my point is this information that was excluded, both objectively and subjectively, could have supported a finding that the defendant had a reasonable belief that she was headed for physical harm, because irrespective of the comment.
But even if that's true, as I recall, the victim's testimony also had to do with timing of when everyone found themselves in the vestibule and when the macing took place, which was very quickly. It was a matter of seconds.
Right.
So it seems that also goes into the calculus as to whether it was really based on fear and based on self-defense, or whether it was more about anger and retribution.
I wanted to address that. My point I want to make is that a reasonable belief that a person is headed for physical harm doesn't necessarily, I mean, generally speaking, the emotion that would be associated with that would be fear. But the fact that a person has anger doesn't necessarily negate the fact that they might believe that they're headed for physical harm. The best example would be a soldier in combat. They might feel that it's imminent that they're going to get shot, but they'd still have to advance if their commander orders them to do so. And so a person could be upset and angry even, and still have a belief that there's a reasonable likelihood of their incurring physical harm.
Are these words alone enough? I mean, my understanding of your argument is that she was afraid that she was going to be harmed by EA because of the text messages that were exchanged. But doesn't EA have to take some sort of physical action towards her to make that fear reasonable under the self-defense law?
I think that in the context here, that might have been, that if that is a requirement, that would have been met by his testimony that he attempted to go around her. These were close quarters. The entry here was a single glass door, not a double door, and he was exiting the outer door at the time he encountered her, and he testified, and the trial court made a finding to this effect, that he attempted to go around her. He didn't try to avoid her. He tried to go around her. And I think there could be a difference. I mean, if things are as volatile as they are in their relationship, trying to go around her might have been a big mistake.
So what was the testimony from your client with regard to her interpretation or her understanding or belief as he tried to go around her?
Sorry, I didn't catch the first part of the question.
What was the testimony from your client with regard to him trying to go around her and how she interpreted that?
It wasn't much. He just said that he tried to go around her. That was basically all he said. He encountered her at the outer doors. From the spray being on the inside of the outer door, I'm not sure if, and also the post and the windows, I'm not sure where exactly she was, but I'm thinking she was just outside of that outer door at the time they both met. And from the video, it looks like you approach that from if you're facing the outside, you approach it from the left, and so you don't head straight on it through those doors. It's from the side. And so he might have not seen her until the last minute. And vice versa, she may not have seen him.
Well, what did she
until he came out.
say? What did she say about him going around her? Did she speak to how that action affected her?
She said it was close quarters. My best recollection of her testimony is that she was distracted on her phone. She looked up, and there they were, both of them, in close quarters, and she was afraid because of the proximity. I think she didn't say that. Those were not her words, but they all stared at each other, and she was afraid that something was going to happen.
So by going around her, does that mean that he stepped toward her? Because going around her could mean that he was avoiding her.
He could have given her really wide berth. I don't know. It just occurred to me that in a relationship like that, sometimes stepping away from a person might be the thing to do. I don't know.
Okay. All right, and then my next question is, was your client required to give notice to the trial court under either 404 or, can't remember the rule number, yeah, 12.2, that she intended to introduce this evidence?
Yeah, there is that requirement. I'll put it that way. But was it raised at trial? Not under 12.2. It was 404 that they cited. And I think that was a little off the mark. I think.
Either way, though, there has to be notice, correct?
Right, and they did mention notice. They were talking notice. It's just that I think the wrong rule was cited, and I was intended to point that out, and argue, or at least raise the point about waiver with regard to criminal rule 12.2. It makes it discretionary on the court if there's a failure to notice. To provide the notice, I believe, is how it works.
Couldn't that be an alternate basis that explains why the trial court excluded the evidence?
It wasn't mentioned at all, and the trial court responded to an argument under 404. And so it looks from the context like everybody was thinking 404 and not 12.2. And also, I think 404 might be the wrong category for this type of evidence. I think it's under 405.
But you concede that 12.2 required disclosure and that this evidence was not disclosed.
Sure does. There was it's in the defense of our office, we did file a notice under 12.2. It's just that it wasn't very specific.
A notice of self-defense.
Yes, they notify them that we're claiming self-defense. But I looked at the rule, and it spells out all kinds of things. You know, you should be very specific about what kind of evidence you want to put on, name witnesses and things like that. So that's something to remember for future cases.
Do you know of any case law that supports that this fits under 12.2, that the disclosure of the testimony of knowledge of prior aggressions and violence is part of 12.2 of the disclosures of 12.2?
No, I do not.
Okay. I have a sort of off-the-wall question, so I'm warning you before I ask it, and it's okay if you don't know the answer. There's some academics that are delving into this whole area of the testimony in self-defense with regard to knowledge of what I'm calling prior violence, aggression, and things like that. Mm-hmm. And there's some thought about, rather than it being under abuse of discretion of exclusion of evidentiary matters, that perhaps that it should be, the standard of review should be as a matter of law, that it's de novo. Would you speak to that if you have any thoughts? That it should be treated as an issue of law rather than an issue of evidence.
It does. It does play an important role in self-defense, and it could be important. I mean, if there were a more complete proffer in this case, the importance of this evidence might be elevated, but the evidence that was excluded. It could make a big difference to a person if they had prior knowledge that a person has a violent, either opinion evidence, character evidence, or specific.
And I'm talking about the exclusion of it, because what we're dealing with is that it was excluded. And I believe you're right that it was excluded because it was treated as if it was only being admitted as prior bad acts. Mm-hmm. So that's where it becomes interesting, because if it was excluded as being treated as prior bad acts, but yet it was really being introduced not as prior bad acts, is that really about exclusion of evidence, or is that really about applying the wrong law and determining how this is going to be governed, and then it becomes an issue of law?
Well, with the 404B, it's two sides of a coin. I mean, it did operate like 404B evidence. It was evidence of prior bad acts, but it was being shown for reasons other than propensity. Well, no, it was used as propensity, I guess. But it was to show that he had a propensity for violence, I guess, and that made her afraid, and she knew of that propensity. And so it did operate like that kind of thing. It's just that when you enter that kind of evidence, I think it falls under 405, I think. At least in the Weatherall case, it mentioned 405A and B, and talked about how on direct it has to be elicited in the form of opinion and reputation, I think, and then on cross, specific instances of the violent conduct. Anyway.
Thank you.
That's about all I have to offer.
And if you'd like to reserve your 5 minutes, you're at time.
All right. With that, I'd like to respectfully request that the court would reverse and order a new trial. Thank you.
Thank you.
Good morning, everyone.
Good morning.
May it please the court, my colleague David Hoffman, my name is Dakota Parrish on behalf of the City of Cincinnati, and I'm going to be asking that you deny both assignments of error this morning. I'll speak briefly as to both. So starting as to the self-defense argument, I believe that the court was very clear in their findings of facts as to what the court found to be true in this case. So in this case, the court did find, in their finding of facts, that the statement, "What's up with that shit you were talking," was something that was said. The court also found that the defendant did mace Mr. Alley. That was fairly uncontested evidence at trial. There was no contestation as to whether or not the macing happened, just more as to the rationale behind why it happened.
What is that statement that the trial court found the defendant to have made? What does that tell us about her mindset at the time of the incident?
Well, I think it goes to several of the elements of self-defense, and I think it goes to both the creation. Well, I think primarily what it does is shows that she was not afraid going into this incident. I think that the evidence that was presented by the state and some of the facts that were alluded to on both sides of this show that the real reason for this whole incident comes down to Eric Alley giving his child Christmas presents several weeks after Christmas. He was having a visit. He was allowed to be there with his mom. She had given him that parental time with their shared child, and he provides Christmas presents several weeks after Christmas. Once the child informs the mother that this is what happens, this is what leads to arguments that are going over text messages. This is what leads to her terminating his parenting time with their shared child. And this is what causes her to go to the scene to retrieve the child and make alleged statements along the lines of she's never coming back to Avondale. That's the whole catalyst for the situation.
Well, weren't there threats? I mean, didn't EA make some threats?
Yes. So what came out during the trial was that there was threats going both ways between both parties, and all those threats seem to have stemmed after an argument about these gifts that were being given. So,
But were they threats of bodily harm that were going both ways or only one way?
I would have to review the transcript. I cannot remember exactly which threats Eric Alley was said to have been made. I think, if I recall correctly, it was something along the lines of "you're going to get your ass beat." Is
Bodily harm.
What he texted to her, and if I recall correctly, that was after she had threatened him as well.
Threatened him how?
I believe there was a threat with a gun that was alluded to in the trial transcript, and then there was also threats to discipline or harm the child.
And so then when she shows up to pick up her daughter and he is walking towards her or around her in some way in this like confined vestibule with that text message in her mind, why would she not then reasonably feel afraid?
Well, because he took no actions to act upon that at that time. He is exiting the building that she is entering. At this point, the testimony was fairly clear from him and his new girlfriend at the time, Brittany Hodges, that she had said something along the lines of, "What's up, Eric? What's all that shit you were talking?" Ms. Fields' testimony was that she did not say that, but that very quickly, as into arriving into that vestibule or opening area, she pulls out the mace and sprays it into the air.
See, but this is what I find interesting because, you know, this state of mind testimony that was excluded seems to spill over into who's going to be credited in their testimony when the testimony starts to become different. Okay? So it's, you know, and whether she's made that statement or not, that excluded testimony could have impacted that. Whether it was proper for her to mace as immediate as she did, or whether she did mace as immediate as she did, because it also, I think, changes on that, right? So it seems to have affected everything. So how would you address, let's say we were to find error, how would you address the harmless?
Well, I am assuming that this court would find error in this case. She was not without being able to testify as to her state of mind. She did testify that she was fearful going into this situation. She had testified as to the toxicness of her relationship with Eric Alley, and ultimately, the court is was the person in the room hearing the testimony from all three parties, and I believe the court properly decided who he felt at the time was being credible and not credible based off of the totality of what was testified to. So I think the court took into consideration what the court believed was the whole catalyst for the incident, and I think the court took into account the amount of time from when they go meet in person to the spraying. I think the court took into account that there's threats going both ways between the parties, and there was no macing that went the other way from Eric to the victim. It was the other way around.
But then doesn't it become significant whether there was threats of bodily harm both ways or only one way?
I think that the fact that there was threats going both ways, but only one party acted on it, is significant in this case in particular, because it could be an instance where it's all bark, no bite from all sides. Everyone's threatening each other. They interact and they both peacefully go on their way, but that's not what happened in this incident. So I think because she was afforded the opportunity to be able to testify as to her state of mind, what she was thinking going into it, and the court still found that they did not believe that she had a bona fide belief is
But
important.
wouldn't that testimony, though, the testimony about his propensity for violence, wouldn't that bolster her testimony and her credibility? I mean, yes, she testified to her state of mind, but that's just her saying that. But when backed up by this other, testimony and evidence about other acts of violence, I mean.
I think that how it was introduced could have been put into a different way if they wanted to get into specific acts of violence. And I do think that when the prosecutor in the room makes their 404B objection at that time, they believed that it was opening doors into things that the prosecution was not prepared to defend against, to call witnesses for, and that was going into the notice aspect of it. As to her fear and state of mind, though, I do believe that she was afforded those abilities and the ability to talk about what had happened specifically in their relationship had anything happened. That was not something that got brought up in this trial. She was trying to bring in evidence of things that happened in other relationships that the state was not put on notice for. And so whether that could or could not have bolstered her opinion, I still don't think the state was reasonably would have been given a fair opportunity to defend against that, to look and investigate whether any of those claims were true or not in this sense.
Can you address the trial court's finding that Fields was responsible for starting the affray?
Yes. I believe, based off of what I see in the record and my interpretation of how everything happened, that Fields was the responsible party for several reasons. One, for ending the visit with the father on the basis that the father got the child Christmas gifts. I also think that it was important
Well,
to
does that matter?
I do think that the reason for the interaction, that was the reason for the interaction. That's what the trial court believed was the reason for the interaction.
Isn't that her right to do that? I mean, I don't know how that is.
I think, yes, she can absolutely terminate, but I think that it shows that she wasn't fearful going into this. This was a spiteful thing out of anger, and I think that
And I think that it can go to state of mind, but I don't know how it goes into whether she was at fault.
in creating it.
Yes, I think those are two very different things.
I believe that part of that is corroborated by the fact that after Fields went to go retrieve the child and came back while Eric was still under the effects of the macing, she re-engages him in an argument and then destroys the gifts out in the street before leaving the scene. And I think that shows the motive of this.
That
and
again
the
goes to
anger.
state of mind. I don't know how that goes into her being at fault.
I believe that.
And I'm asking it because I'm struggling with that. I'm struggling with what was used to make that determination, and looking at, like, what is it that creates who's at fault here?
Doesn't that inquiry focus on who started the violence?
As to who's at fault for creating,
Yes.
Yes, but I would also argue that the argument started because of the Christmas gifts and because
But let's change the facts a little bit to flesh this out.
Okay.
Let's say that there's no mace and she does nothing other than simply show up under the same set of circumstances. She's upset about the Christmas gifts. They've exchanged these angry text messages. She doesn't like how her daughter's being treated, and so she shows up to get her daughter. But instead of her macing EA, he beats her up. Would we still be saying she's responsible for the affray? I doubt it, right?
I don't think so in that scenario.
Exactly. So doesn't the affray inquiry focus on who starts the violence?
I think that's the primary, but I do think that the context of the fight and what caused the fight is important as a whole to give context.
So what facts did the trial court look at in determining that she started the violence? I mean, clearly she maced him, right?
Correct.
So was there anything else that happened leading up to that macing incident physically?
I think that there's somewhat of a time element of how quickly the macing happens. I do think that there's some facts where Ms. Fields' testimony was that she sprayed it generally in the air, but the other testimony is that it hit Eric. It was towards him specifically and directly, and I think that the evidence that he suffered from the macing, but that Brittany did not, corroborates that fact as to showing that this was more of a violent thing rather than a self-defense incident.
So she targeted him.
Correct.
And did he do anything to her? Does the record reflect, was there any testimony that he took any physical action towards her?
No. I don't believe that anything was presented that he took any affirmative actions or made any stances or face or anything to provoke it once they are all in the same vicinity together. I believe that everybody's testimony, whether or not you take into consideration whether or not that statement was made or not, is that this happened fairly quickly when they walk in. They all walk in and very quickly after Eric Alley has been maced.
It seems to me, counsel, that the at-fault of who initiated the affray seems to come down to what you just said, the proximity of meeting in the vestibule, the quickness of the use of the mace.
Correct.
Now, that hinges on giving credit to the victim's testimony and discrediting the defendant's testimony, which seems to, I think there's an argument there that then hinges on that the excluded evidence could have impacted that determination. Because we have to also take into account that there is a text threatening the defendant with bodily injury, right? And so, depending on how you look at it, that can become the cause or the party with fault of initiating the affray, right?
I would disagree on the basis that I think that even if you remove the statements or the alleged statement or what the court found, the statement of what's up, that shit you were talking, for the parties to have had a mutual argument over text messages where there's threats going both ways and the defendant walks into the vestibule, and if we take the defendant at her word that she didn't say anything and reactively within seconds pulls out the pepper spray and maces Eric Alley, she still she's the first one to violence in this without him. She didn't testify.
But here's what's also interesting. I'm going to add this into the formula, is that both sides agree that finding each other in the vestibule came to was a surprise to all,
Yes.
right?
Yes.
So there was like didn't expect this to happen. And I think that has to be considered in the calculus of this.
And even still finding them all together in this vestibule by surprise, I still believe that Miss Fields took the first action at this point in pulling out the mace without
I don't
knowing
disagree
whether or
with
not-
that based on how the trial court credited the testimony. What I'm questioning is whether it is harmless error, if there is error, assuming there's error, whether it is harmless, disallowing this state of mind testimony.
And I would state that it is harmless because of the actions that are undisputed as to he did not do anything while they're in the vestibule to show signs of violence towards Miss Fields. They all surprise come in to the same room or area, and then within seconds, mace is going into Mr. Alley's face, and this is, and while there were threatening text messages going back and forth each way, he had done nothing at this point when they're in person together interacting for the first time that day, indicating that he was going to cause her harm at this point.
So as a matter of law, is it required for there to be an overt action on top of the threat? Because he did lodge a threat.
I do believe that words would not be enough for this incident. Because we know nothing of very specific threats like, once you get to the vestibule and I'm here, I'm going to beat you or hurt you or something like that. It was more general threats that were testified to beforehand. If threats are going both ways, then I believe that he could have been also entitled, like reversing it, would he have been entitled at that point thinking she's threatening to harm me, I can beat her up in this vestibule and claim self-defense? I believe that would have been proper, especially had she not taken any aggressive actions towards him. I think that this is an incident where they had both been threatening each other. They come into contact, meet up for the first time in person. Since these are going, he takes no actions on.
But I think we can put in the calculus, if she knows of prior propensity of violence and he gives a threat of violence, whether under those circumstances there needs to be an overt act, especially when the defense is the use of mace. So we're not talking about deadly harm here. We're talking about the use of mace. So I think that needs to go into the calculus too.
And I think non-deadly tools, even tools that are primarily used as defense tools, can still be used to harm other people. There was testimony that she knew what the mace would do to Mr. Alley.
Because I'll tell you what this case made me think about. You know, for years we've told women to carry mace. So I'm walking down a dark alley under night and I hear somebody behind me and I get really concerned and I feel that that person is walking faster and faster. So I turn around and mace them. Am I now going to be looking at some sort of a assault charge?
I don't believe so based off of those facts, because I think some of those facts are differentiated from the facts in this instance where you're talking about an unknown subject behind you, someone who may be walking a little bit faster. You've put yourself in an alleyway and you've given, to what I'm hearing, facts that would lead to a bona fide belief of physical harm from the person behind you. Under those facts, here we have, despite threats going in both ways in this instance, you see each other face to face, and then mace. There's no action that was done by Eric Alley at this point to where she would have been able to testify, he took a step towards me and then I maced out of fear, or he made a face, he made a snarl, he made a comment, and then I maced. It was the victim and the victim's witnesses' testimony was that there was a comment of what's with that shit that you were talking, and then the mace, and then you have Miss Fields' testimony of she comes in, she sees, and almost immediately she sprays him in the face, but lacking there is what he did to provoke macing other than these texts that had been sent prior. There's no lunging, nothing was testified as to him doing anything at that point when they meet and they're shocked to see each other as to him causing her harm in that instance. So it's a preemptive attack on him.
Would there be any circumstances in which somebody could be reasonably afraid just by words? So in other words, if somebody was sending me a bunch of text messages threatening me, threatening to kick my ass, threatening to hurt me, whatever, and then I saw the person, and do I have to wait for them to try to harm me?
I would think that everything is going to be fact dependent. I think that specific evidence and testimony as to what those threats may have been that were texting and the context, are they one way? Is if someone's sending a lot of very specific one-way text to another person.
Does it matter that it's one way?
I do believe so.
Why?
I believe that the one-way threats show more intent in carrying them out rather than when someone's reacting to threats being with more threats. To me, comes out as more of an argument. And that's why I alluded to this could have been an all bark, no bite situation where both parties there's testimony that they were in a toxic relationship. We don't get a whole lot beyond what that toxicness looked like or what that was, but when we have some evidence as to what that could have looked like where they're both sending each other threats, there's no testimony or there's no evidence that they had ever been violent with one another in this instance, other than that they just were toxic, and we can see that based off of them sending each other threatening text messages. And so I do believe that, and I would caveat this, since I think everything is fact specific, and that's why the law, that's why we have this system, that's why we have the trial courts, the appellate courts, and the Court of Appeals to help us go through these situations, because not everything is cut and dry. But I do think that a lot of one-way threats means something different than two-way threats, especially with the context that they were in a toxic relationship with one another.
Counsel, your time has expired.
Thank you.
Thank you.
I may be stretching things a bit with regard to the analysis for finding fault, but if you would expand the scope of the events to be considered, in the facts you'd have the fact that my client in the messaging gave notice that she was on her way to pick up her daughter. The daughter, the victim in this case didn't have to stick around. The daughter was with his mom. It was like a neutral third party for the visitation. And in the videos that are part of the exhibit here, the police encounter the mother, and she even says out loud that she told the victim to skedaddle, but he didn't. 45 minutes, he was there for 45 minutes after she gave notice that she was coming on her way, which is sort of code for, I don't want you to be here when I get there. Or at least it would be prudent to leave before she arrives to collect her daughter. So if there's a little fault to go around, that could be considered. I mean, she'd testified she did not expect him to be there when she got there. And so that was part of the surprise when she encountered him in close quarters at the vestibule. Also, one more thing. With the notice comment, there's lots of ways you could prove these prior acts. You could bring in witnesses, like maybe citizens that know of the person, the victim, and his propensity for violence. And you know, you would list those witnesses, but there were no extra witnesses. It was just the victim, or the defendant in this case, who testified. So I think that would mitigate some of the possible harm from not giving notice, that the prosecution wouldn't be totally flat-footed. They would expect that the defendant could testify. So if there's no further questions, I'd ask that this court would reverse. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.